Publication wasn't done. Governor Waller got the publication done. It's 5 weeks. And he gave that man the pardon. And so my position is that Governor John Bell Williams wanted to pardon him, but they both knew that the publication requirement hadn't been met on one of the crimes. And in that pardon, and it's of course over Secretary of State, but Governor Waller put it in his actual, all that's written in his pardon, the reason that he gave it. So yes, sir, I think that is an example of where governors knew how it worked. And so our position is that it has been followed until now. And the reason they put this notice provision in the Constitution is so that people would have notice and it wouldn't be a hurried situation. It'd be a setback.
Let me ask you, General Hood, to make sure I understand what you're saying. You're saying since 1890 that every pardon granted by any governor has had an applicant and 30 days publication.
I can't say that just because I don't know that we've been able to go back and check. I know we went back and checked some of them, and it was brought to my attention that one was a correction.
What about Governor Fordyce? I think it was 12.
13, yes, sir. 13.
Were there applicants and publication for every one of us?
Your Honor, I don't know. We have done some. This is, as you know, an unusual case. I mean, y'all had 2 days to get ready after we filed the briefs, and we've had 2 days to get ready, and we've been scrambling trying to do that. But it's our position. We're just contesting these.
Well, we have to consider that, though, General Hood. We've got pardons dating back to 1890. We've got custom and practice can be recognized as authority. We have to consider the unintended consequences of what you may argue that may be articulate, it may be have good justification, but what is the effect on pardons that Governor Fordyce did if a different route is taken from previous practice?
Your Honor, in the 1923 case, the governor had a file and had an application and proof of the pardon. They knew it in 27. Governor Waller knew it in 1974 when he granted that pardon. And so I'm just going from the records that we have as to how they knew how it worked. So it's not a change anything. The change occurred in 1890 when people took that power back from the governor. They made it a condition precedent to the authority of the governors. In other words, Governor, you don't have pardon power anymore unless you make sure that the publication has occurred for 30 days. If it's a weekly paper, you do it once a week for 4 weeks, plus in the next week you have to go over the 5th week to get published for 30 days total.
Let me ask you a question, General Hood, or really two questions. First of all, you, in discussing a minute ago the actions of your office, I didn't hear you get to what I read to be the central challenge in Governor Barbour's brief. On page 8 of his brief, he flat out makes this statement, which I didn't hear you respond to, and I'd like to hear your response to it. Governor Barbour makes the allegation or the statement the governor's office contacted the Department of Corrections before November 24 about this, and it says Scott, referring to David K. Scott, your assistant. Scott told Neely in writing 35 days before the governor left office that he, Scott, would undertake to have the required notice published on behalf of each one of the 5 pardoned mansion trustees, and then it quotes, or reportedly quotes, language from, I think, a text message, as you pointed out a minute ago, and the quoted language in here is, MDOC will take care of those still in custody. And my first question is, I'd like for you to clear that up or explain your position with respect to whether or not Mr. Scott had authority to represent that they would take care of this publication. And the second question I have for you relates to what you said about Montgomery. If I could get your answer and then ask my second question, I'll sit back.
Yes. First of all, the governor can't shirk the duty off on blaming on somebody else, no matter who it is, that he or she did not first make sure that publication was proved. So all of that really is not relevant to this constitutional interpretation. However, I'd love the opportunity to try to correct some misstatements in there. I don't believe Charles wrote that brief. that is, they tried to mislead the court. And when that email came, that text message came through, the sequence was the first communication is November 28th. I think in the governor's press conference he said something like they had a meeting on the 23rd, but apparently they called Chris Evans. And this is all speculation. I'd love to depose these folks to figure out what happened, but that should be done, I suppose, at the lower court. But then the first communication was November 28th, and David Scott by Commissioner Epps told him to communicate with the governor's office, and so he did. He texted Darrell Neely and said, on November 28th, he said, look at section 124 in the publication requirement. So nothing happened until December 6th after 5 o'clock. The text from Neely, it says the big guy or something, I can't remember in the quotes what it said, but the big man wants to publish. And that's the first communication. David Scott's answer was MDOC, not Attorney General. MDOC, his client, will take care of the publication. So I think that's the proper sequence that occurred.
Would that mean for your assistant, a lawyer from your office, whose client is MDOC, to say, MDOC, my client, our client, I think the point that the governor was making in the brief was that if the lawyer makes a representation on behalf of the client, it's pretty binding, or generally has been under the law, and why doesn't that bind your office?
Well, because he was nothing but a conduit for MDOC, number one. He was just relaying the message. And the governor is over the Department of Corrections, and they shouldn't have been in the publication business. It says the applicant shall publish.
So you're just saying it's not binding?
No, sir. And if it were,
okay.
And I'm saying,
I don't want to make you spend all your time explaining. I just want to get your position. You're not denying he said it. You're just saying it's not binding on your office. Let me ask you my second question. You talked a lot about Montgomery, and the part about Montgomery that I want you to address that concerns me is a lot of talk about no case on point. We never had it. This is an issue of first impression and all of that. And I grant you that I don't find a case where this precise issue has been discussed in terms of the pardon. But the Montgomery case, as I know you well know, has language in it that's difficult to reconcile with the argument you're making now. The Montgomery case has language that says the governor, and I'm reading from the case, the governor is the sole judge of the sufficiency of the facts and the propriety of granting the pardon. And if the governor, if that's true, if that's binding precedent on us, if the governor is the sole judge of the sufficiency of the facts, aren't you here today asking us to review the governor's determination of the facts regarding the publication?
Justice Dixon, you hit the nail on the head. It is a dissent that was not joined by other judges. Well, in the dissent, it talks. I think we're confusing Metz.
What is the dissent?
Montgomery on.
Metz is the dissent in Montgomery.
Well, it's in Montgomery, the dissent in Montgomery.
I'm quoting Justice Etheridge, who wrote the majority, I think, and it's language from the case. Am I wrong about that?
Correct.
I think.
Am I wrong?
No, he's correct. He's quoting the majority opinion in Montgomery.
Justice Etheridge had said in a prior case, I think what you're referring to, and I apologize if I misled you with respect to the case I'm referring to. In a prior case, Justice Etheridge had talked about and used the power of the governor to pardon, and he had said in a dissent, as a for instance, had nothing to do with the case, said it as a for instance, the courts can't go behind the governor's pardons with respect to things like publication, which was just an aside. But then in this Montgomery case, he wrote the majority, and General Hood, this is of great concern to me. You really need to address this. In this Montgomery case, this court said, and I'm reading to you from the case, the governor is the sole judge of the sufficiency of the facts and of the propriety of granting the pardon. And I'm having trouble seeing what is raised in this case that is not tantamount to whether or not the facts are sufficient to lead up to the granting of the pardon. Are you understanding my question?
Yes, sir. I
Okay,
think so.
explain to me whether or not this publication was was made, or whether or not it was for 28 versus 38 days, or the number. There weren't those factual determinations that this court determined in Montgomery was a thing or an exercise this court would not engage in, that the governor is the sole judge of the sufficiency of those facts, and we don't get into it. And to me, that's pretty binding precedent, even though it's not talking about in Montgomery the precise issue of publication. It is talking about sitting in judgment of the facts.
Yes, sir. My recollection is that Justice Etheridge wrote that dissent where he says this court can't go into the facts issue. I thought that was in Metz. Maybe I'm confused, but let's just, wherever it is. I know what the language you're talking about.
I'm in Montgomery.
Okay.
The case you've been citing.
Yes, sir, in the dissent. But Justice Etheridge wrote a treatise on Mississippi constitutional law after that. And in his treatise, he doesn't use that same language. We cite that on page 17 of our brief, where we talk about Justice Etheridge later writing that.
But you're not suggesting Justice Etheridge can reverse a decision by writing a treatise.
Well, he has reversed, I believe, his position in his treatise from what he wrote in dicta previously in that dissent, and that was one dissent, and that was in.
I understand that's the dissent, but what the language that Justice Dixon quotes is from the majority, also written by Etheridge in Montgomery. That's a 1923 case, and that is the language of the majority opinion in that case. He, the governor, is the sole judge of the sufficiency of the facts and of the propriety of granting the pardon, and no other department of the government has any control over his acts or discretion in such matters.
Here, General.
The language of Montgomery, which comes a few years after his dissent.
I know the language you're talking about, and the distinction is that that's right, the propriety is some of the language that they placed that you just read. Propriety. We don't dispute that. We agree with it. That you can't go back into whether or not, it was.
We all agree that we're not going to look at the wisdom of granting the
Yes, ma'am.
pardons, correct?
Yes, ma'am. But this court has authority to look at the validity.
You don't skip over now. It's not the propriety that I asked you the question about. It says two things. It says the governor is the sole judge of two things, General Hood. In the quoted language, it says the governor is the sole judge of, number one, the sufficiency of the facts, and number two, the propriety of granting the pardon. Now, I'm not asking you about the propriety of granting the pardon. I know you concede that. That's the governor's, that's his prerogative. And I'm asking you, what do we do up here on this court? What do we do in the face of a case that's binding precedent on us? What do we do in light of the fact that this case says the governor is the sole judge of the sufficiency of the facts, and that no authority other than his judgment and conscience can determine whether it's proper, and that no other department of government has any control over his acts or discretion in such matters? That's pretty strong language for us to have to deal with here.
The sufficiency of the facts as to who should be granted the pardon is what the position we take. That's what that language means, as opposed to, this court's got to, if in the veto power, for example, this court has looked at a constitutional authority of a governor and said that a partial veto is invalid numerous times. And so that's a constitutional provision. This court looked at it and said there may be prerogative of the governor to veto. Nobody else can veto. This court has the authority to look at whether it's legally and done correctly. And that's what we're saying here. This court has the authority to look at whether or not the governor followed Section 124 legally, not on the fact issue.
General Hood, I'm not sure that you've answered Justice Dickinson. I'm interested in that too. The sufficiency of the facts, I think, directly modifies the pardon. And it would have to deal with the application and the publication would be the sufficiency of the facts underlying the pardon. So is your position that doesn't say that, or how would you then interpret that? Basing, I think that's a fair reading.
I think that what Justice Etheridge was talking about here is that it's dealing with what the facts were, the reasoning behind why this person needs to get a pardon. These pardons we're discussing, at least here today, they don't state any reason as to why, or whether publication was met and so forth. Like Governor Walters had specifically stated that publication was met. I'm saying that what this court has authority to do is look at the legal validity.
Well, do you make any distinction in the case of treasons where it's specifically, where it say, in the case of treason, you shall have power to grant reprieves combined with the consent of the Senate? Is that, do you make any distinction with that versus the pardon that 124 in that case provides a specific review?
My distinction is that the constitutional framers at the convention decided on treason. We're going to move part of the powers of the governor over to the Senate. But as far as our notice, our right to be heard, our right to notice, and an opportunity to be heard, we're going to reserve that unto ourselves. And so that was the people saying, Governor, you don't have this authority unless you do what this publication requirement says. So they gave some to the Senate, and I think historical record shows that there had been abuses and last-minute pardons. And so the people said, wait, let's at least have 30 days, period, where people can have notice, and the fourth branch of government, the media, will have an opportunity to know that a pardon is about to be granted, and that a governor isn't rushed at the last minute and does pardons that have the wrong county and errors. So
help me there, because I couldn't research my staff's research. You just said that prior to 1890 there was an abuse of some sort, that some type of empirical data that we can look to. Is there some type of legislative history, constitutional convention minutes, something that you're pointing to that said that this is the reason this was put in there? And then the larger question for me is this. The power of pardon is, we have this wonderful three-branch of government that is best in the world, that our forefathers, certainly set up and we have followed. But the pardon is a check on the judiciary to some extent. And so this court would not have absolute authority to review, in each instance, many aspects of a pardon. And so I think that that's the big issue here, is, as Justice Dickinson pointed out, if the court is limited by case law, it seems to me that we have a larger hill to climb than it seems on the surface. And so I would like your response to the governor's check on the judiciary, and what type of empirical data do you have indicating that there was some type of abuse that the 30-day requirement was for?
Dr. Eric Clark wrote his thesis on the history of the 1890 Constitution, and that was something that we cite in our brief. And we've also included the Clarion Ledger, the daily Clarion Ledger, minutes of what occurred, as well as the Constitutional Journal. We cite those as authority, and Dr. Clark's thesis, it indicates that there had been abuses. Now, we cite other court cases around 1890. Apparently, that had happened after the Civil War. The governors had begun to do some things that people didn't like. And there's a treatise that, I don't know if it's an ALR, but there was some citation that we have in our brief that lists a number of cases where courts had interpreted constitutional or statutory restrictions on the authority of the governor. In those instances, those states had either granted it to the legislature to do those restrictions. Now, so that's our the history of it. Now, your second question was,
well, you reminded me of another question. If the application process, who is it for the benefit of? Did the people through the Constitution say, you know what, we're going to vest in the governor of this state the authority to grant pardons, and therefore he can approve those pardons whether there's been an application or not, whether there's been sufficient publication or not? But you disagree with that, obviously.
Yes, sir. It's a constitutional right of the people to have that notice. It's due process. That's government at its basis. The people reserve that right. And that constitutional provision, Section 24, has rights to the judiciary. Where you find somebody that could affirm someone being guilty, the power of the pardon affects they're in your realm. Once the governor, when he steps over that line and doesn't follow the Constitution, he is in the domain, invaded the province of the judiciary. So there are three constitutional rights or constitutional issues there. One, the power of the governor. One, the right of the people that was expressly reserved unto the people, as well as the judiciary's right to have its orders carried out.
General Hood, I'm not We have to do the best job we can, just look at the Constitution and see what it says. And what somebody reported back during that time may or may not be of a whole lot of value. But when I look at the Constitution, I'm just looking at the words. And if I understand your argument that the provision regarding notice is a mandatory provision in the Constitution that exists before the governor can make a factual or any other determination regarding a pardon. Is that correct?
Yes, sir.
And that the court is a guardian of the Constitution. It's not what that governor or any other governor or any single person or even any one of us judges that decide what the law is. The Constitution controls. Is that your position?
Yes, sir.
Let me ask you a question, if I could. On in one of the briefs, there was or a couple of the briefs, there's a discussion, sort of a parallel discussion about restrictions on the legislature, which could be named or called conditions precedent, the term you're using and others have used. With respect to the legislature, there are constitutional prohibitions against the legislature, for instance, passing a revenue bill in the last 5 days of the session. I know you've read those arguments, and I'm interested in your response. I think one of the briefs points out that it's Section 68 of the Constitution prohibits revenue bills the last 5 days of the session, and the legislature, notwithstanding that constitutional prohibition, did it anyway. And the matter ended up in court, and I think the case was Hunt v. Wright, an 1892 case, a couple of years after our Constitution was adopted, which is pretty close in time. You would assume at least some or most of the framers of the Constitution were still alive at that time and knew what they meant and understood what they meant with respect to what was in the Constitution. And nevertheless, in addressing a question where the legislature hadn't done something in order to pass a bill that the Constitution said they have to do before they can pass a revenue bill, it has to be introduced 5 days before. The court said that the constitutional provisions regulating the legislative department, I'm reading the case, constitutional provisions regulating the legislative department is addressed to and mandatory to that body, and with which the courts have nothing to do in the way of revision. The bottom line being that I think court took the position that it may be a constitutional requirement, and this goes back, I think, to what Mr. Fortner said in the very beginning. It's not so much a question of, as you've been arguing, that it's a condition precedent or it's required or what the length of publication is supposed to be. Assuming one concedes all those questions, and you're right, it is a condition precedent, it is required, they didn't publish notice properly. The real question, according to Mr. Fortner, and it seems to me perhaps according to Hunt versus Wright and other cases, the real question is, violation or no violation, does this court have the right or the authority to review it? Do we have the right to go behind it? We said we didn't have the right to make such review in Hunt v. Wright. Why do you say we do now in this particular instance?
Well, the Cup case as well, you know, this court said numerous times that they have are not going to get into issues in the legislative, what they've done correctly over there until there's some act passed, until there's some action taken. And that's the same position the court's taken with the governor. You're not going to, you know, get into the operation of what the duties of the governor are until they take some act. And if that act violates the Constitution, if it violates separation of powers, if the governor steps over into the domain of the judiciary or takes away constitutional rights of people that have notice, then this court will.
That happened here. I mean, that happened. The legislature passed a bill. It was challenged. And the argument was made, the law is not valid because it violated a constitutional provision that prohibited the bill to be introduced in the last 5 days of the session.
Those are inner workings of the legislature. It's kind of like the decision in Limber, where recently we wrote about IHL and the president at MUW that those are inner workings, and we're not going to get into that. But once, for example, the governor can call out the militia. It won't affect the constitutional rights of anybody, or there's no, in that provision, there's no other rights of judiciary to have anything to do with it, or the people for that matter. That's the sole power of the governor. But when he or she is acting in the domain where there are other constitutional rights involved, this court will engage. Now, with the legislature...
Wait a minute, what constitutional rights are you talking about?
Talking about the constitutional right of the people. The people reserved unto themselves in Section 124. Right to know.
Why is the people's constitutional right to have notice? Hear me out here. Why would you think the people's right to have the constitutional right to have notice of the application for a pardon is more important than the people's constitutional right to not have bills passed in the legislature affecting revenue, affecting whatever subject matter the people choose, have those bills introduced in the last 5 days of the session? I don't see that. I hear your argument, and it's a good argument, that the people decide what limits they want to put on government. And if they think those limits are so important that they put those limits in the Constitution, they're important limitations, and I agree with you, they are. And you know my position on the Constitution. I think it means what it says, and I agree that when the people put a limitation in there, it's a limitation. But why do you elevate the constitutional requirement for notice of a pardon higher than the constitutional requirement that the legislature introduce those revenue bills more than 5 days before the end of the session?
Simply because it addresses the inner workings of the legislature. One branch is just, y'all had, the courts had just been hesitant to get into whether they read a bill like in Tuck. Those type of internal issues, a court is hesitant to engage.
But General, that's what Justice Dickinson is referring to is a constitutional violation. And I hear sometimes across the street toward the end of a session that they cover the clocks on the wall. And let's say they did that for 5 or 6 days before the session was over and started passing all these revenue bills, and the governor signed it into law based on this case. We couldn't look at it. Would you say we could?
I'm not sure that case was decided correctly, John. I think that if there's a constitutional violation, this court not only can look into it, it has a duty to look into it.
Let me ask you on this point, going back to, let's assume for the sake of argument here 2 things, and then I've got 3 questions for you. Let's assume for the sake of argument that we find we have authority to review these pardons. And let's say for the sake of argument we find that there's a constitutional violation. Then number 1, what remedy are you asking for?
The remedy is the same remedy that we asked for in the partial pardon case, partial veto cases, that they be held void. That's a remedy, and that's what this court's held 3 times when a governor has tried to partially veto a revenue bill and keep the money and not follow the conditions.
And secondly, what would you say about whether any decision of this court would be applied retroactively?
Well, the law hadn't changed, as I've stated. In the 1890 Constitution, in 1923, it showed that the governors knew how to keep the files. This Chevron case that they cite, not the Chevron deference case, but the Chevron case addressing the issue that you're talking about, was later reversed. And so we don't believe that it should be followed.
All right, and finally, and I think I asked either Mr. Portman or maybe Mr. Griffin, harmless error analysis, see if we found a constitutional violation. What would you say to that?
Your Honor, that's as a prosecutor, and have worked in the criminal division, we frequently make that argument in a criminal case. I don't see that it has application in a civil case of any kind of harmless error. It's a constitutional violation where we believe that people reserve that right was violated.
But so would a violation of the requirement that you bring somebody to trial within the speedy trial constitutional right granted to defendants in criminal cases. We hold it all the time, and you argue all the time that those violations under certain circumstances are harmless error, and all kinds of other constitutional violations you argue are harmless error. Why would there be a difference?
Well, first of all, the Barker versus Wingo factors that are applied to determination of a speedy trial right was violated. That's what we argue it on. The reason for the delay and all those 4 reasons.
Well, one of the big reasons is prejudice, though. I mean, this court's made a very big factor out of prejudice, and who's prejudiced here?
Well,
if the government was going to sign the pardons anyway, who's prejudiced? What